and how do we embed these values within our innovation processes? Because very often legal remedies for some of the harms that we see that arise from the use of digital technologies are often too late. Often we don't know that harm has already occurred unless it's occurred at a kind of aggregate sense or to a collective. And so it's important that we think about both these upstream and downstream strategies together as we think about the digital transformation of our societies. So over the past year, maybe even longer than a year now, Donna and I have been looking at this issue of the use of smart automation or artificial intelligence, machine learning technologies in the Indian judicial system. I think the research was provoked by the e-courts proposal, the third version of the e-courts proposal, which articulated a very clear role for the use of AI. And that kind of set us thinking on what could be the potential, what might be some of the harms, and how do we contribute to this conversation early on before we see undesirable technology and policy lock-ins, and so that we can steer these trajectories towards more equitable outcomes. So just in terms of the structure of today's event, I'm going to now hand over to my colleague Donna, who is a research associate at Digital Futures Lab and the co-author for this report. She's going to walk us through some of the findings and suggestions that we make in this report, and then we'll open it up for Q&A for about 10 minutes, after which I'm going to hand over to Jhalak Kakkar, who is the executive director of CCG, to moderate a panel discussion between a really fantastic and excellent bunch of thinkers that we have here with us today. With that, let me hand over to Donna, who is going to walk us through the report.
Thanks, Urvashi. Thanks for the introduction. Hi, everybody. Thank you for joining us today. I'll jump right into the presentation. And Urvashi's already set the context for why we have this report and why is it that we're discussing it now. There's a lot of movement on AI that's happening globally and in India, and combined with what's happening in the e-courts phase 3 document and the recent budgetary allocation to the e-courts project, we anticipate that there is an incremental approach to the greater adoption of AI in the judicial system in India. In terms of methodology, we have used a combination of research and qualitative interviews. These interviews have been anonymized, but we've interviewed lawyers, legal scholars, computer scientists, economists, etc., from India for this research. And the report is broadly classified into 3 parts, where we've mapped the landscape of AI use in Indian courts. Then we look at what the challenges are, what are some emerging harms and risks in this context. And we conclude that the present scenario is one of organized irresponsibility, and that we need a careful innovation approach to adopting AI for courts in India. So in terms of the mapping part that we've done, we've looked at emerging and existing use cases. And please note that these are not core AI products or pilots. Some of them are building blocks that can be used for more analytics. Some of them are rule-based logic systems that use some data to automate some part of the justice system. So we've categorized these into 4 parts: process automation, information management, legal analytics, and online dispute resolution. Process automation is where some part of a procedure has been automated for EC working around procedures. So for instance, some summon servers or process servers have been automated, where it automatically records the location where the service was summons was served, or automatically records the time of said service. So that is like under process automations, that's the category. Information management is around, because we have so much data that's coming out of judicial records, etc. There's a need to facilitate access to this data, use this data. So there's a lot of work that's going around in building these data sets, in building the National Judicial Data Grid, in building interoperable criminal justice databases, and then also using that information like for translation. So Supreme Court had sometime in the last 2 years introduced something called the translation software that used AI to translate legal documents. Legal analytics is again an emerging space. There's a bunch of pilots and products that are taking shape in this area, where this data that's emerging from judicial records is being analyzed. So there are these case summarization or case analysis softwares and some research and development happening in academic institutions for predicting judgments in bail cases, etc. Online dispute resolution, again, this is taking place in both within and outside of formal institutions. In our report, we focused more on the formal institution of online dispute resolution. And an example from last year is that Rajasthan has adopted an AI-enabled Lok Adalat. Now, again, a caveat here is that we don't have publicly available information where exactly AI is being used, if AI is being used for case allocation, what the purpose of AI is, but there is a lot of information that this system has been adopted in courts. In terms of actors, as you would expect, there are a lot of multiple actors in this space discharging different roles. We have not listed all of this here in this slide, and our caveat is that this is not an exhaustive list because there might be actors who are involved in closed door discussions who might not there be in the public list. But the executive is the funding authority for the e-courts project. The judiciary, the e-committee is implementing the e-courts project. There are academic institutions that are developing tools, again, legal startups developing tools, policy organizations that are contributing to policy conversations on the use of AI for court systems. So there's a whole bunch of factors, and there is an emphasis among these actors on improving the efficiency of courts, reducing costs, saving time. And I'm going to use this particular approach to efficiency, time, and cost to go on to the next bit around the challenges we've identified for the adoption of AI in courts in India. And the first challenge that we see is that there is this mismatch between what the problem is and what the solution is. And we lend this to a kind of oversimplification of problems that the judiciary faces in terms of being simplified as supply and demand issues. And it lends itself to technological solutions where tech can come in and solve some small problems. But we already have scholars pointing out that this is not merely a supply and demand issue within courts. There are massive issues around court culture, around power dynamics between parties that contribute to existing issues of pendency and delay, which cannot be reduced to tech solutions and are not amenable to tech solutions. So therefore, there is this problematic framing of what the problem statement itself is when it comes to AI solutions. The second is around the lack of data, and this is in terms of data is not standardized across courts. What a case means may vary across a district court or high court. Data is also entered in a free text basis in many of these databases. So it's not, there are mandatory fields that are supposed to be filled. So a lot of data could be missing from databases. There's also this infrastructure and capacities problem where hardware network connectivity might not be uniform across court complexes in India. In terms of capacities, there is a chasm in terms of expertise at this intersection. So the understanding of technology, what technology can do, it also varies across different actors. And fourthly, there is this problem of an inadequate governance and accountability system. And here there are two core arguments: that governance in terms of data governance, that we don't have a data protection law. Judicial records are public documents. It may contain sensitive and personal information, even though the case information management system redacts certain information around sexual abuse. There might still be some kind of proxy data to identify personal information in judicial records. The other is around accountability problems in terms of who is making decisions to procure certain AI tools, who will be held responsible if something goes wrong, if and when something goes wrong. So there are those accountability issues in this context as well. And for the accountability, but like one example that we've also used in the report is one of the courts in the country, they'd adopted a smart court solution, but it was retrospectively approved by the cabinet. And so there are these haphazard decision-making processes that are in place, and no real way to kind of identify who's making the decision and what would be the accountability framework for that. And we use this to build out our argument that considering the number of actors that are in this space, the number of decisions that go into adopting these AI solutions, and the kind of harms that may emerge from this is a scenario of organized irresponsibility. And the definition's on screen, and we have borrowed this concept from Ulrich Beck, a German sociologist who coined it in the 1980s in the context of environmental risks. And the basic premise is that when there are multiple agents who are part of decision-making process, it's difficult to trace back accountability when harms are compounded, when risks are compounded. And a very basic example of this could be that, say, an individual who's using a plastic straw does not contribute on their own to environmental harms, but the collective use of plastic straws could lead to environmental harms. So we hinge our argument on this scenario of organized irresponsibility in the context of adoption of AI for courts in India. And there are multiple harms that emerge from this kind of chaos that's already in place. And we've documented some harms. We see harms happening in other sectors. We see harms happening in the judicial sector in other countries. And we've categorized these harms into 4 broad buckets of individual harms, of collective harms, institutional harms, and structural harms. So individual harms at the level of, say, right to violation of a right to privacy or a denial of right. And there are instances of legal determinations leading to denial of rights in other jurisdictions. So an example is in the US, automated background checks were being used for tenants, and they would misattribute people as criminals, thus denying them the right to housing. Another is around collective harms, where those harms occur out of group affiliations. Your data set is skewed or not representative enough, and there's bias arising out of that. The third is institutional harms in terms of arising out of the responsibility and accountability gaps that already exist. And for example, who will detect errors when things go wrong if there's not enough accountability or a framework in place? And an example that we use is of, like, say, automation bias. In the UK, there were e-forms that were calculating matrimonial alimonies. And for the longest time, they were miscalculating these alimonies, and nobody detected them because there's an over-reliance on technology to make these calculations, and hence these errors go undetected. The fourth is a broader structural harm, where we talk about the transformation in judicial values itself, which would come around from the adoption of AI for court systems. And this relates to how self-perceptions change, how work culture changes. So for instance, in Israel, they've adopted something called LegalNet, which templatizes judgments. And judges would often value themselves for the quality of their tailor-made judgments. And this kind of structural change, it raises almost existential questions on the value of work, on their work culture, and what is it that they do in courts. So therefore, moving on to this, we do see there's a lot of actors, there's a lot of this risk of harms. There are potential risks that emerge from the adoption of AI for courts in India, across the world. And we therefore need a very careful approach to how AI is being used for courts in India. And the set of recommendations we have is in addition to legal guardrails. This is not to replace legal guardrails or existing accountability frameworks, but we do need systems in place to ensure that AI is adopted in the most, if and when AI is adopted at a large scale, is adopted in the most careful and responsible way. So our first recommendation is around purposeful openness, and this has to do with data. There's a push for open data, but the idea is that openness is not always value neutral. And an instance that comes out in India itself is in Karnataka. The digitized land records were used by folks to dispossess the marginalized who might not have enough land records to prove their ownership over land. So we need to ask questions like around openness. What is the purpose of keeping a certain set of data open? Whose interest would be served from keeping the data set open? Who's going to use this? So then have a very purpose-driven approach to having data out in public. The second is around community-led design, and community-led design, like participatory design, is quite prominent in policy conversations, but it's very difficult to implement meaningfully. And we suggest that we should move away from this focus on like individual efficiencies, focusing on improving, say, a judge's efficiency within court, to asking more questions, like engaging more people on questions on who that particular tech is going to benefit, who will be able to use a particular information that's out in the open. So one example we use is that in the US, public defenders for the cases were given access to surveillance data. But they had no way of parsing or analyzing this data on their own. It creates more dependencies on others to use that data. So there was never this question that do they require data in that form or do they require it in some other form? So therefore, like engaging different stakeholders in that process of bringing in automation. The third is around capacity strengthening, closely related to this process of who gets to use what data, do they know how to use the data? And both AI and law are like highly technical fields, and there is that difference in people's understanding of these fields. So you need to build those capacities to understand the tech people use so they have agency to use the tech. The fourth is around the responsible investment criteria, that funders and investors should be very responsible in terms of where are they investing, for what purpose are they investing. And we suggest that one of the parameters in their impact assessment metrics could be to look at the impact on communities and institutions of the funding that they do. The fifth is an iterative accountability, and this is closely related to the point that technology in itself is very fast changing, keeps on moving. So we need to be responsive to those changes to account for harms and risks that emerge from these changes. And the idea is that ultimately this justice system as it exists now is fraught with inequalities, and the adoption of AI should not be used to entrench those inequalities. I'm going to stop here and see if you have any questions.
Thank you. Thanks, Donna. Thanks for that presentation. We'll be sharing the link of the report. I think Sasha will be posting it in the chat shortly, and it's also will be available on our website. So please do have a look. I see there's one question in the chat from Dominique. And Dominique, before I kind of hand over to you, I just wanted to just make a small kind of point in addition to what Donna was saying. Is that, you know, the motivation or the reason for this report, just to go back to where we started earlier, is that we hear a lot of enthusiasm in kind of policy circles around the potential of AI, and the use of AI, as you know, should be apparent from Donna's presentation, is still at a very nascent stage. And so what we wanted to do here is point out some of the harms, point out some of the challenges at an early stage before these systems kind of get locked in, right? And I'm just saying this because so you know, we felt that there was already a lot of enthusiasm and a lot of narrative around the potential positive impacts. And so we wanted to come into this conversation by saying that these are some of the things that we need to be cautious about before we start implementing these systems at scale. I see one question from Dominique in the chat, and just for the kind of ease of flow, I'm going to read it out rather than handing it to you, Dominique, if that's okay. So Donna, is the push for AI in courts led by demands from the judiciary or executive, or do software vendors hawk their platforms in an effort to create a market for AI solutions? I think Donna's video has...
model where...
Sorry, you froze for a second, but now you're back. Yes.
Right, but we also see this model where a lot of vendors or software developers come into the system in the hopes that they can leverage the kind of use that will arise out of in a code system that will say 20,000 people use it, and then they can maybe go on and use the software at some other forum. So there is, I think it works both ways, where the judiciary has certain demands, and there is a focus on those solutions, like for example, like around case analysis, case summarization, research assistance tools. So that comes out of the needs of the legal community. But then there are also these like financial models where startups would hope that they get this kind of leverage from being in this code space.
Yeah, and just to add to that, I mean, I think, you know, among some of the people that we spoke to, we did get a sense that amongst the judiciary, there is some skepticism or some reluctance about the use of technology. But at the same time, there is a kind of policy push towards adoption of technology. There's a strong emphasis on kind of values of efficiency, so on and so forth. And there is a big knowledge gap or a kind of capacity gap between, in terms of like the understanding of that technology. So in a lot of cases, you have private companies selling or overselling the potential of these technologies, and there not being enough kind of capacity or knowledge to be able to critically evaluate whether the particular technology, the particular AI solution that is being proposed actually matches the problem at hand. Donna, there's also another question from Avnika on whether you could provide some examples of harms observed across courts in different Indian cities.
Right. To be fair, we don't have too many documented harms from the use of AI in courts in India, but just because, I guess, Urvashi mentions at a very nascent stage. But we've seen is there was a 2017 report on this case allocation software that was being used in the Supreme Court, which was randomly changing dates. So then the cost list was changing, people were missing dates in courts. So we see very few examples of actual harms. We see harms in other sectors from the use of AI, but in courts itself, because it's at a nascent stage, a lot of pilots are happening. We don't see enough impact evaluations around those. We don't see documented harms in this.
Yeah, no, just to add to that, I think also just picking up on the last point that Donna was making, there's also a lot of opacity around where these systems are in use, who is using them, how have they been used, what the kind of impact is, aside from the fact that they're also at a very nascent stage, right? And in some cases, for an example, it is only in the public domain that they are being used after they've already been implemented, not there hasn't been a public discussion or any kind of deliberation around them. So there is a lot of opacity around that. And some of our kind of analysis of what the potential harms might be are also based on observations from the use of AI of the judiciary in other sectors, in other jurisdictions and other geographies. So what we did do for this study was also look at examples in the UK, in China, in Israel, in the US, and draw on those examples to hypothesize what some of the challenges might be and how some of those challenges might even be accentuated in the Indian context, given our particular socioeconomic demographic framework, as well as the lack of existing guardrails, whether it's a data protection bill or even more transparency around kind of public procurement of AI solutions. Is there a list of pilots that we were happening? So in our report, we do outline some of these pilots, and we do give them, when we do provide examples of the pilots. We don't have an exhaustive list of them, but maybe that's an interesting exercise for us all to do as a kind of community, is to see if one can actually build this kind of database of where this might be happening and leverage our kind of collective intelligence on this. Donna, I don't know if you want to add something to that.
No, I agree with that, that we do have a sort of a database or a list of some pilots that we know are happening, but again, there is some opacity around this. So we don't exactly have a count of the number of pilots that are happening across the country in different ports.
And maybe we'll take one last question before we hand over to the panel, Donna. So could you provide some examples on the sort of oversimplification of problems that such solutionism has brought about in Indian courts or otherwise?
Right. One is around docket explosion, and I'll go back to the supply and demand issue here, that there are too many cases that are coming to courts, and therefore we have this long list of judicial reforms that have been around. Let's increase the number of judges, let's increase the number of courts, let's bring in more fast-track courts and save more time. And this is the kind of solutioning that we also see within this technology space as well, where AI can be used for, say, fast-tracking processes, of reducing some time in the process, for example, that the person does not have to end up spending more time in manually entering data, etc. So these are some of the instances we see in place within like technology in courts in India.
Yeah, just to add to that very quickly, I mean, there's a lot of the narrative around the use of AI is really around the kind of pendency issue, and like Donna was saying, it's framed as a kind of supply and demand issue, but there's not enough analysis of what are the underlying causes of this pendency issue, and just improving kind of case management systems, etc., may not actually address those pendency issues. Mosmi, and I think the question that you're asking on whether the increased focus on tech takes away the importance of the equal focus on people in such as the behavioral components, such as power dynamics. I think the dependency question, is a good example of that. There's multiple reasons why there are these delays, whether it's people's inability to access the courts because of the various geographies they live in, or socioeconomic conditions, or organizational culture within the courts, or also just the strategic reason why certain parties to a dispute might want to drag out the dispute, and that being intentional, it not just being something that is because of a slow process, but because that allows for perhaps rulemaking because one side has greater resources, etc. So I think in a word, yes, to answer your question, Mosmi, and I think we do elaborate on it some more in the report. I'm conscious of time, and we do have really fantastic speakers lined up. So I'm going to hand over to Jhalak for the next part of our discussion, which is on the panel discussion. Jhalak Kakkar is the Executive Director of the Center for Communication Governance at NLU Delhi and also a visiting professor. She works extensively on AI regulation and data governance, providing policy comments to the Indian government and international organizations. She's an expert member of the Global Partnership on AI, as well as a member of the Working Group on Data Governance. She's also an expert member of the UN Broadband Commission Working Group on AI Capacity Building, among other expert groups. Jhalak actually has a much longer and even more impressive bio than what I just read out, but we'll save that for a little later. Jhalak, so over to you.
Thanks, Urvashi, and thanks, Donna, for that great overview of the report. I enjoyed reading the report, and I'm looking forward to discussing it with the amazing panel that Urvashi, Donna, Sasha have curated to discuss this important issue. This issue assumes special importance given the general push across the country in digitizing various governance mechanisms, and in particular, given the e-courts vision that the judiciary has articulated, which has elements of not only digitization, but adoption of artificial intelligence in court systems, as well as opening up data sets around courts. I think, this is a very, very timely discussion to be having. I'll start off with posing a question to our panelist, Prateek Sibbal, who, as part of his role at UNESCO, has really been, looking at the capacities and experiences of judges from different countries, what their attitudes are to digital transformation and adoption of artificial intelligence in courts, and would also love to hear from him on, what from all of these discussions he believes that the role of AI in the functioning of a judicial system should or should not be.
Oh, thank you, Jhalak. Thanks, Urvashi, Donna, and Sasha for having me here. Also really enjoyed reading the report. Really well done, especially all the challenges, typology that you've created. Also very helpful for some of the work that we are doing at UNESCO. So just for a little bit of context, and I know there's limited time, at UNESCO we are working on capacity building for the judiciary on issues related to AI and the rule of law since about 2020. And as part of this work, we launched a global training, but we are also doing in-person training. So we are in touch with different judicial systems on what kind of digital transformations are underway, and it's not always only about AI. So coming to your question, Jhalak, I think one of the things that we always see is first some bit of skepticism that, oh, what is this, and why will it replace us? Can AI systems replace judges, when we talk especially of examples around predictive justice systems? But when we start really unpacking the systems and we say, okay, there are actually issues with data, there are issues with representation, the things that Donna described earlier, they start understanding, okay, so AI systems are not like a God-given infallible thing that if it's a formula which is giving you a result, that is something that you have to accept. They say, okay, so there are challenges and we need to understand. And I think that's very important point to drive across to the judiciary, that it is something that you can use as an assistive tool, with the important point being that you have to put all the safeguards and to do ethical impact assessment of these tools before and after their use, and importantly be conscious of exactly this idea that the report covers, the socio-technical dimension, right? Because if you are using a technology, someone is embedding that technology with a script, and this script is what is going to mediate our experience of the justice system. So to align all the philosophy of technology and then the practical implications of AI systems, I think is very important. And once they have a hang of these things, I think the conversation becomes much more grounded in the realities. So we were doing a discussion, I think last year, where we were having judges from Malawi, from South Africa, and they were like, okay, so all this is fine, but there are challenges around connectivity, there are challenges around affordability. You can talk about all the brouhaha about access to justice and this will transform. But no, it doesn't work, because sometimes it's just too expensive for people to join online, or there are issues as simple as digital literacy. So I think these are very important points to flag in this whole digital transformation of the justice system kind of conversation, that you need to focus on the users, you need to focus on the people, and then design systems. But I think I will stop here with just mentioning some examples. It kind of complements what Urvashi mentioned before regarding US, UK, and we've also actually looked at examples, for instance, in Brazil, where they're using AI systems for looking basically what a general comment procedure if there's a case that needs to be listed for appeal faster. So these processes have become faster. But similarly, in Colombia, they used a system called Pretoria, where there were issues with transparency. So they had to stop it. They had to rework the whole thing, and now they are deploying it. So there are different practices emerging, and I think it's important to learn from these experiences around the world on what works, what doesn't work, what kind of guardrails we can keep. So in that sense, I think this report is also very helpful for us. Thank you.
Thanks, Prateek. Ushaji, if I could come to you at this stage in the discussion. One of the things that I've heard you speak about is the need for the adjudicatory process to be pro-poor, less complex, responsive, and really be accessible to all, irrespective of economic and social incapacities. Prateek is already pointing to some of the challenges we see emerging with the deployment of AI within the judicial system. You've also spoken extensively about the challenges of digitization that have been taking place within the country. So within, these two premises of, having a judicial system or adjudicatory process that's accessible to all, and the broader challenges of digitization that we've seen as it's being rolled out across the country, what are some of the specific learnings you think are important for the judicial system to take into account?
If I can take a certain liberty and say that since you've already said what I say otherwise, let me say something further. The first thing is that I read your report and I read the e-vision, that 3.0. What I found fascinating in that is that the whole report was about how the judiciary and how it works has to adapt itself to technology. And so it wasn't, the solutionism was a very awkwardly positioned thing, because the whole thing was about it being seamless, and technology can do these things. So allow technology to get into all these places, and the judiciary has to adapt itself in its functioning to that. So that's something that I felt I need to keep in mind every time I think about what's being done with this. The second thing I find fascinating is that judges are constantly telling us that they know nothing about technology. Forget about AI. Any use of technology, what technology represents. We know that the Supreme Court gave us this incredible judgment on privacy, which had to do also with informational privacy. But if you ask them to apply that to their own system, I don't think they're anywhere near understanding it. The third thing that that really has me thinking is this idea of innovation as being something that should be allowed. So experimenting on whole systems, on whole populations, and all of that. And we talk about the independence of the judiciary as if it is something completely divorced from all of this. Like it is only independence from the executive. Actually, it's a lot about independence from private interests. And we seem to forget that a lot. In fact, your report kind of brings in people, the people who you say are involved in it, the report, which brings in people, for instance, like Egg Step, like OMIDR, what's the other one? Like, Infosys having gotten into IT, into GSTN, into all kinds of things, and getting into every system and reshaping it to fit what it has as a product. So I think any study can't start with this. I mean, any application actually can't start with this, that we say, now we have to bring in technology and we have to bring in AI. Let's see how we are going to do it. I think that's that's part of the problem. In fact, on YouTube, before I stop for this time, on YouTube, you'll find that there are various places where judges have gone, where while they've been talking about the introduction of technology somewhere, they say, but I knew nothing about it and I know nothing about this technology. I think it's really important to help them understand what constitutional issues are involved and where you can use technology and how you need to be careful not to allow the inferiority complex that's being given to everywhere that this technology goes. They say, you people are useless, we'll create we'll provide a solution. So to think beyond that inferiority complex and to be able to demand answers, and if you don't understand it, don't take it. If somebody can't explain to you what this is, and if you're not convinced, don't do it.
Thank you for that, Ushaji. I'll come back to you. I have some follow-up questions, but I just want to give all the speakers an opportunity to make an opening round of remarks before sort of coming back with further questions. So Professor Krishnaswamy, if I could come to you. One of the things that the report talks about is sort of the tension between two values, the managerial values of efficiency and cost avoidance on one hand, and democratic values of judicial independence, equity, fairness, justice. And what do you think about this tension? And also, is it useful to move away from an understanding of justice as service delivery and really refocus on democratic values being at the center of a discourse around automation in courts?
Yeah, thanks, Jalak, and congratulations to Donna and Urvashi for seeing this report through. I'm sure that that it took quite a bit of avoiding, common frames of reference to write a report like this, and it reads refreshingly for that reason. And so that I think a big congratulations is in order. I would respond to your question, Jalak, in a slightly different way. I don't know that the real trade-off, as is suggested in some parts of the report, is between efficiency and efficacy of the judicial system and justice values on the other, or democratic values on the other. Any careful empirical understanding of the Indian legal system would have to admit that the rule of law costs, or the justice costs of the current state of the system, are near unacceptable on any version of justice. And if we don't take that seriously, then the costs that we pay are visible to us in the forms of vigilantism that are available on national TV today. We have a culture, both popular and political, that celebrates these forms of self-help. And there is no moral counterforce to that idea unless you can operationalize a reasonable legal system. We would always have disputes around the edges as to how a legal system must work. But I don't think we should sharply set up a trade-off between efficiency, efficacy type concerns on the one hand and justice or democratic values on the other. So I would lean on the side of saying there is a problem. And we might craft and shape the problem definition in different ways, but if we do not recognize the foundational problem of the legal and judicial system, then we risk much else that we hold valuable. A rule of law society, a constitutional democracy. That's what's at stake. So I see the value framework that we cast on an issue like this to be quite different from, say, technology adoption. And I'm just going to be slightly facetious. I'll just say in agriculture. What is the place of AI and drones in agriculture? We can have many interesting views on the question. I think that is very different from asking what is the place of AI and technology in justice. There's something to that problem of scale and the urgency of that problem that I think deserves special attention. The second point that I want to make, and I'll stop with that what is the solution? Is the solution AI? I think is a question you ask, and a question that the report kind of skirtingly asks. It kind of suggests that provocation, but it never squarely asks that question. And here I want to just say something by way of background, that India's gone through, I mean, there's a way in which there's a screaming out that anyone is a Luddite if you suggest that technological adoption and diffusion literature teaches us that there are sometimes useful stages in technology adoption. The US Supreme Court today conducts oral argument in person and entirely by telephone. I know that Indians and some Indian judges might valorize the fact that we have digital participation in some courts. But my question is the way I look at this problem is very different. The first phase of eCourts 1 was about putting desktops on people's desks. And it took us the better part of a decade to even produce typewritten judgments. And even that is not uniform across the board. The second phase of eCourts was apparently about networking. And even today, the court systems are not networked, by which I mean nothing moves through the internal network. And today, we're gathered here to talk about AI. It's a very important and I think very significant technology shift, not one that can be ignored. But the framing of appropriate technology and diffusion, which is a STS framing, it's a development economics framing, I think is very useful. I know that the report uses Beck and the risk society as a sort of framing as to where we find ourselves. But there's another useful framing that we can bring to the question of adoption, which we might have much to learn from. So let me just stop there, hand back to you, Jhalak.
Thank you, Professor Krishnaswamy. I think the first part of your comments tees it up very well for the question I have for Napinai, who's the only practitioner actually in the court system as such amongst all of us on a recurring active basis. So Napinai, I think Professor Krishnaswamy points to the realities of what the overburdening of our court system looks like, the implications on justice, rule of law, achieving sort of democratic values, what that means. So in that context, and really engaging with the court system on a daily basis, what do you think are the opportunities and the limitations of digitization more broadly, but the use of AI more specifically in starting to tackle some of these intractable problems we are facing within the judicial system?
All these problems and all these questions in 2 to 3 minutes, I'll definitely try my best to cover that. So good evening, everybody. And it's so lovely to meet old friends and new on this platform. And I look forward to meeting all of you in person soon. And hearty congratulations to Urvashi and Donna for their lovely report. But the more I read the report, the more concerned I became about how much more we have to broaden out the discussion or the narrative, right? And that's where I would like to guide today's conversation from, as you rightly said, from a practitioner's perspective. Nowadays, I wear many hats, but at the core, I'm a practitioner. So I'm happy that I can stick to my core in today's discussion. See, when we talk about AI and codes, and let's just talk about AI first itself. Is this something that we can really eschew? Can we run away from the use of AI? Can we forego the possibility of usage of AI in any vertical? Judiciary is just one amongst many, right? So at this juncture and where we stand today, and where we stood nearly 5 years or 7 years back too, there was no way we could run away from the usage of this technology, or for that matter, any technology. At every point of time, forget about the pre-independence time, we have had the judicial systems which are fairly robust. We have had laws which are more than centuries old. But at every turn, whenever you speak about law, and particularly in the context of judiciary, and particularly in the context of litigation, the first thing that comes to everybody's mind is about the backlog in courts, right? Here is your first use case, therefore, for AI. Here is your first use case, according to me, for adapting technology. Everything and anything that we do, whether it is in the physical mode, whether it is any other kind of process-driven methodology, everything will have pros and cons. So I personally feel that anything that you adapt is going to come with problems. There will be strings attached. There will be trade-offs. So what is the trade-off, and what are we willing to give up for, and for what purpose? And are we just running behind that proverbial rainbow, chasing the pot of gold? Or is there some real reward or remedy at the end of that rainbow? So I feel that on one hand, yes, we need to identify and we need to answer the problem statements that the use of technology will always bring up. But that these problems exist does not mean that we can run away from adaptation of this technology. We cannot eschew that technology, to put it very simply. So that would be my first point here. But having said that, you have to adapt this technology. It cannot be thoughtless or rampant adaptation without ring fencing. I think one of the questions was already asked about ring fencing and who's going to bell the cat. But in that, again, that's a long answer. I'm not going to go into that. This is just my opening statement. So I just want to leave you all with these 2 or 3 thoughts that I have. So the second thing is, when you're adapting AI for courts, you need to be careful in terms of what you're adapting it for. And automatically, there is this fear mongering, or there is this jumping to the final step, which is of replacing lawyers, replacing judges. We are not looking at that, and we are nowhere near that. Let's first talk about the very first step. And I think that's where this report comes in a very critical manner, because it throws the highlight on the collection, the lack thereof possibly in some instances, and the usage of data. The entire reports focus on data, which is the fuel that was likely to drive AI and where it is going to go, and how it could modulate a usage. How it could modulate adaptation is a criticality, which I noted, and I'm sure that the authors will be in a better position to address why or what their focus was. But this is what my perspective was when I at first did, when I first looked at the report. So the second thing which I would say is, I wouldn't even say if. It is about AI already forming part of court systems and being adapted for more court systems, right? So in that adaptation, my batting has always been for usage where it is process driven. And we should not forget the biggest learning that every single case pertaining to AI has brought up: the human in the middle. So ultimately, when you look at the use of AI, use of case laws that have already evolved, you'll see that the law that has been laid down is that a human will ultimately have to review, should have oversight on whatever AI is suggesting, whatever AI is concluding upon, whatever AI's decisions may be. If you're using a natural language processing system, and these are all old technologies by today's standards, and to cull out something equivalent to what ChatGPT is doing now, ChatGPT is only giving you the guidelines. It doesn't mean that's going to be a last project. I'm just giving ChatGPT as an example and not promoting it or asking people to adapt to it. I'm just saying that you can't assume that merely because an AI system has given you certain answers, that is the final response. That is the final report, or that is what you can rely on because ChatGPT said so, because X AI system says so. When I draw directly in terms of Compass and US laws for that matter, right, where they upheld the validity of the use of the constitutionality of the use of Compass for deciding on sentencing, but clearly laid down that the human element cannot be taken away. Ultimately, that can be looked at as indicative or persuasive, but the judges decide finally, right? So that's the next point I wanted to make. And I wanted to close out on this aspect about responsible AI, transparency, etc. These are all very powerful words, but we need to see it in action. So when we talk about adaptation by courts, the first and foremost usage, which I see as a very positive effect on the judiciary and the functioning of the judiciary, is to use AI to study the processes that are leading to the backlog and how you can resolve this problem. Use technology, use multiple technologies to resolve it. It is easily resolvable. If we are going to keep blaming judges who are already overworked, or lawyers who are even more overworked, and believe me, we are, and then that's not the solution. Obviously, the problem lies elsewhere. Obviously, we are a very litigious country. So using technology here, using it to segregate that which can be easily closed out to those that need further, how do you allocate time? How do you process the whole thing? All these are easily feasible with the use of technology. It is only at the last level we are talking about replacing judges or lawyers or even law clerks, etc. So let's not jump the gun here. Let's talk about the fundamentals. First, of course, is data, and that leads to AI bias, etc. And India is a very diverse country. So, of course, I'm concerned about AI and bias when we talk about the Indian perspective. But let's also structure the conversation and in the context of usage of AI to meet practical requirements when we speak about judiciary and litigation. Over to you, Jen.
Thanks so much, Napanay. If I can just go back to Usha ji and pick up two threads that sort of emerged from the remarks that she made. One is the idea of whether the court will apply principles of informational privacy to itself in the context of the rollout of, any such sort of e-courts, digitization, AI-based systems. And secondly, the role of the private sector in designing and implementing automation in courts, and what some of the accountability concerns around some of this can be.
It's actually at an interesting time that they are talking about technology. I won't say AI now, but it's technology and the courts and the judiciary. Because it's not like what happened when the UID was brought in, or when they started applying that across the board for creation of multiple databases. We've gone past that stage. We have that experience in hand. There are some lessons that we've already learned from it. One of those is that, okay, I'm not starting from the most or least important. Something that I've witnessed very recently, this question of data entry errors, huge errors. There is a man sitting in, and I don't know how many more there are, I know of one who's sitting in prison today because in the, in data entry, the wrong UID number is put into the wrong bank account number. he's told that the government has sent him money. He withdraws that money bit by bit over 2 years. Nobody notices. And then they say, oh, but you've gone and linked your number with somebody else, and so you've got to be in prison. So the people who won't know what this technology is about and who they are going to be, these are the most vulnerable in our midst. And they're going to be even more vulnerable because they have no clue. They're told, and that's what they know. It's not even like they have a place where they can ask these questions, follow up. In fact, this whole design of introduction of these technologies is happening without any feedback mechanism, without grievance redressal. We are told that you can call it like a customer and leave your complaint, and then it will be dealt with. That's the best that they're able to do. So this is going to be one huge kind of problem. The second major problem that we've seen is that, even within the judicial system, the way in which we think about the problem and the answer to that problem. I mean, how are we going to deal with the problem? There are no solutions. But we try and keep improving on it and keep moving towards something that's better. If you look at what happened in Hussain Ara Khatun in the late 70s, you'll find when the court passed the orders that they did, they passed those orders because they felt that the right to liberty is important. And so large numbers of under trials just sitting in prisons for long periods of time, they said, you can't have, what are they doing inside? And so produce whatever you need, personal recognizance bond, whatever it is, but they've got to get out. By the early 90s, the problem had shifted. It had become about backlog, pendency. It's about the legitimacy of the institution. So they bring in other kinds of solutions where they are saying, all right, let's see what are the cases that we can do away with, which we don't know, what are petty cases. Now they won't think decriminalization. I mean, these are places where you really need to apply your mind to it. Instead, you say, let's just put them all into one category and see how we can deal with them. Then when that is insufficient, they say plea bargaining. For all people who may have committed an offense up to 7 years, who are the people who are going to be in prison who will be willing to go in for plea bargaining for offenses that are punishable maximum with 7 years? It's not, it's not the people who can afford to get themselves lawyers and pay their bail and walk out. So actually, this system has been so heavily weighted against the poor, against the vulnerable, and it's not like the poor have a choice of whether they come into the system or not. So we are adding one more thing to this, one more level of opacity, and one more potential area of error, which they then have. It's already happening, which is why I gave that one illustration. In fact, in Orissa, Napine, differently from what you were saying, I'm actually seeing something slightly different, where after it's taken this long, because there has been denial and denial and denial that people are dying because they're not able to link people, various kinds of things happening. Finally, for the first time, you've had a government in Orissa saying that, old people and pensioners, they can't deal with your system. They can't give their biometrics. They can't come to your bank. They can't deal with this. So will you please allow us to go back to a system where somebody will kindly go and give the old and disabled what they need to survive? So actually, it is, some of these systems, but the purpose of this, we know that when the income tax change happened, and the TCS system had existed and Infosys came in after that. And they found that the Infosys was defective. So they said, okay, let's go back to TCS while you set this right. And they said, no, there is no going back. So we are also talking about deliberate ways in which we are burning our boats. So judiciary needs to be aware of many of these things. And I don't know that, so private company can afford to have errors in the system. They are only building up businesses for themselves. They are not responsible for fundamental rights. The court is. And if the court doesn't understand what it is that private companies do, that's one whole set of things. And the other thing is that when you have databases of this kind being created, you're now talking about integrated interoperative systems, like you were saying. This interoperability is supposed to, automatically provide information to police, to prosecutor, to this person, that actually the whole point about the judiciary is that it hears everyone. It doesn't become a part of that system. That is the executive system. So we are changing something that is fundamental when we say that this is how it needs to be done, and this is efficient. So we really need, the thing is, it's not enough to question whether technology is good or bad or whatever. It is important to understand what the values of a judicial system is. And if we are not clear about that, then it doesn't make a difference, what we put in where. I mean, a simple thing, like, during COVID, they said, prisons are overcrowded, so let's release many people. And then 1 year later, they said, okay, now COVID is over, all of you come back. Why? Isn't liberty still your priority? What happened? So I just think that, we need to give it some pause, because the judicial system, I mean, apart from the fact that all these records are in terrible condition, and imagine them becoming the database on which anything is going to be built up. It's, we are also, digitization per se is not a problem for me. I actually think, when we digitize something that we have for ourselves, it helps. But digitization, we know by now, is the first step to centralization. Is that okay? I mean, I really think we need to think about these things before we, and the point about technology is they're saying, it's just generations that are coming up so fast. We don't have time to think. Let's do it. If it gets wrong, then we'll adjust. So in Tamil, we have a thing which Napine may remember. We have a thing called Pizhai Gizhai, which is in a very famous film that came in. The poet writes a poem. So another poet takes it to the king and says, can you give me the reward, which is 100 gold mohurs? Can you give it to me for this? Then he says, read it out. He reads it out. And the court poet finds an error in that poem. The poet who's taken it there says, okay, reduce the amount that you have to give me for that error, which is Pizhai Gizhai, mistake. Le lo yaar, give me the rest. So this whole innovation that has been happening by experimenting on the whole population has been full of Pizhai Gizhai. This is Pizhai Gizhai technology.
Thank you, Usha ji. Professor Krishnaswamy, if we can just, one of the things you alluded to when you were making your comments earlier was, we are looking at we're focused on technology, and we're maybe not looking at, that we're focused on other mechanisms of improving the court system, but maybe not really studying the underlying methods. And I know this is something you've also written about in a law review article about a decade back. And in that, you sort of argue that, it's important to use empirical methods to really understand the underlying problems within the court system. But there are challenges with that due to unavailability of crucial data, right? And one of the things that the eCourts project really talks about is opening up, cleaning up, curating, judicial data, making it accessible to a range of actors. So what do you think are some of the implications of opening up such data? And, there are obviously opportunities, like you've sort of alluded to. But there are also risks. What are the kind of risks you anticipate, and what are really the guardrails we need to set up if such a system is being contemplated for rollout?
Yeah, thanks, Jalak. And I'm going to start with what I mean, one of the features of the report that I really liked, which is that when one reads the eCourts 3.0 draft or final, I'm not very sure what is the status of that report. Let's assume it's the final report, which is referenced in this study. You get a very disjointed sense of the field, as if it were written by several people. It has several voices. It does say some of the things you said, that curating and cleaning up data, these are all useful and good things. But if I just stay with the question of foil and comparison between the two reports, this report expresses in its methods section a sort of almost like a failure, an admission of failure, that we haven't talked to the courts or the judicial system. And I think this is the strength of this report, that it actually hasn't got into a game which is a completely insider game. It stays outside of that framework. It says something fresh and interesting about the field. It's a policy field that unfortunately has not deserved as much attention as it should. And so I think this report is very useful in this respect. The problem with eCourts, which is the question you asked me, is that eCourts 3 is written as if eCourts 1 and 2 never happened. So there is no account of what happened in eCourts 1 and 2. What did you try to do? what did you manage to do? What actually got delivered? What didn't quite work out? And then suddenly we have E-codes 3, and then we say that now we're going to do something different and bold and daring, and this is going to work. My sense here is that as this report, I think, very, very politely calls pilots, I would call them gimmicks. There is a real risk that we have in the AI story, which is that we have a genuinely transformative technology, almost designed, tailor-made for the practice of law. The 3 core functions of legal work: search, text to speech, speech to text, as well as let me make sure I get my notes right so that I don't say something that I didn't want to say, and as well as the part about text generation, right? So all of this generative text technology, I think that depending on how we do it, the legal education, the legal system will not look anything like what we know. And the only question to me is, how quickly is this going to happen? That's the only question. It may be that it's adopted by the courts, not adopted by the courts. If it is adopted by the courts, it will happen in public spaces. Otherwise, it's going to happen in private spaces. It's going to happen. Now, this is a very different point from what I said about appropriate technology. I think that we are responding to a technology form that is peculiarly well designed for the law. It's almost as if this was done for law and legal systems. Now, then what is the risk? The risk is that we don't have a scaled, empowered, humanizing adoption of this technology. All the things that Usha is referring to. Who does this empower? Does this empower people who need to be empowered? Will it simply empower insiders in the system? Does it humanize the experience? Does it make for the courts to be more, we have courts that barely have plumbing and sewage systems and toilets. So maybe we can humanize the experience of dealing with judges and the judicial system. So the real question is, how is that adoption going to happen? And there are, of course, serious political economy questions as to what kind of technological rollout will take place. So my sense here is that we are at E-codes 3. We don't know what we make of collectively of E-codes 1 and 2. E-codes 3 has a new promise. A new promise is a transformative technology. All things considered, there are good reasons for that promise. How we adopt and deliver and what guardrails we build around the technology will really be the key question. And the report kind of concludes with that. So I don't want to preempt the other discussions you might want to have before we get there. But doing the AI segment right is critical. Doing the technology adoption right, I don't think we can go straight to, there's been some references even in this panel about how we're going to talk about AI substituting adjudication. I think that is really far down. Machine models doing adjudication is one of the kind of sort of N+5 stage. We are really talking about some very elementary uses that can be quite transformative of a legal practice and the courts. And doing it right, the greatest risk, okay, I'll close with this, Chalak, and hand back to you. The greatest risk to my mind is that we do it wrong. And the risks of that are that the erosion of the legitimacy of the courts will occur at one of the most inopportune times in the history of this country, because we indulge in a form of non-scaled, non-empowering, not humanized gimmicks that will ultimately, we won't have much to stand on for those of us who are passionate about the court system and the judiciary being a viable organ of a constitutional democracy. That is the greatest risk, that we have a transformative technology and we botched this one up like we botched up e-courts 1 and 2. Back to you.
Thank you, Professor Krishnaswamy. I think that's deep sort of area for us to all reflect on. I'm going to start taking some of the questions from the audience and maybe requesting a particular panelist to respond to them. One of the questions here from Dominique is about who sets the guardrails and frameworks that regulate any such deployment of AI? Does government take the lead, or nonprofits, private sector, or a combination of them all? And if I could request Prateek to come in here, because I know UNESCO has been working within, with governments, with judiciary, around enhancing capacity of government officials to engage with AI, as well as sort of helping judiciary wrap their heads around the deployment of AI system within courts. Prateek, you have done some thinking around this issue, so it would be great to hear from you.
Thanks, Chalak. So I think on the there are several regulatory initiatives, right? There are different kinds of initiatives. So for instance, you have the EU, which is taking a very hard law approach and going along with their risk assessment framework and the no-go areas and the high-risk categories. So that is one approach, but it is taking a very long time to get there. Then there are standards, there are technical standards which have been put out, which can also guide some of these developments, where you can, when you are, for instance, deploying these systems, you start with some kind of impact assessments, looking at the data, looking at whether the AI system is transparent, looking at the potential biases, looking at the exclusion, and so on. So you already kind of, by design of your system, integrate some of these safeguards. And these can be done either through technical standards or process guidances, which I understand from the report that do not exist or are very heterogeneous, and anything and everything is going on. So I think there's a range of solutions, and there are already so many guidances. For instance, UNESCO has come up with the ethical impact assessment. The Council of Europe has come up with the human rights HUD area, what they call. So a range of these tools are available. We have to see and inform the judiciary to start deploying them, to train them to use these, because we can't always wait for the regulation to come and then these things to start, because that's going to take a long period of time. So yeah, I'll stop there.
Thanks for that, Prateek. Napinay, one of the comments from Pragati is that the goal is definitely about bringing the system closer to the source, rather than adding a tech layer that takes away from the poor. Optimization in this case is lowering the burden on the judicial system by automating processes that help in decision making. I think maybe this begs some reflection on what technology can really play a role on within court, and what the limits of sort of technology can be over here.
I don't think the question or your summation is making it very clear. Is there anything specific you want me to? Because on one hand, the query draws on an assumption that technology will take justice delivery farther away from the poor. Am I right in interpreting it in that way? Jala?
I think Pragati will have to speak to.
I would rather that Pragati raises the query, because I'd be happier to address the actual query raised rather than the way it's structured. Because the structuring does not really give clarity to the query.
Hi, hello. So my question, I didn't really have a question here. How I was looking at it is we are looking at innovations in health, and in sectors like health and judiciary, there's a lot at stake to put in AI. So the decision here becomes that what processes can we give to AI, like, we can replace with AI, and what processes we cannot. And that's where the decision, like, of course, AI can come in a lot of places. It can actually make the final decision if you put in a lot of data over the years. But do we give it that authority? And how do we enable AI to bring the judicial system closer to the case rather than making it further away? So how we look at it in health is how do we bring the tertiary care, like how do we bring the professionals closer to the villages rather than making the farmers or the rural people travel more to the tertiary care. So that's the entrance I was bringing in. So I wanted to know what are the processes here that can be optimized and what cannot be, even though AI can do it, but where's our limitation?
See, be it health or the judiciary, I don't think the situation will ever come where the technology will be taking decisions. If it comes to that, then it is definitely a worrisome process. The second part of what you mentioned about us not, and I think it actually ties in with the concern that Usha also raised about whether it is all then becoming more centralized rather than decentralizing, which is the whole federal or quasi-federal system, which is the Indian perspective, right? The quasi-federal system mandates or presupposes decentralization. So I believe, correct me if I'm wrong, Usha, but my understanding was that was probably one of the reasons that this concern arises. It may not be right to equate the whole usage, and because it's a very basic usage of technology in terms of, though of course the costs are high for courts, with the functioning of virtual courts, the hybrid mode now, or the virtual courts during the COVID phase. I'm just using that as an example. I know that that's a very basic usage as opposed to the use of AI, etc. But just to give an example of where technology could take us, and to also alleviate this concern that it will always result in centralization. What I see as a reality is, and this is something we have been asking for a long time, and very vociferously, that justice should be accessible to all. And for that to happen, the Supreme Court cannot sit at the head of a nation and ask others to come to it. The courts have to be accessible to the commoner, right? To the Aam Aadmi, to every single person, and within reach. Now, we did not have benches being put out in the 4 regions as was originally mentioned, or in 6 regions, or anywhere else, because the conversation still continues on how do you segregate between an appellate bench of the Supreme Court as opposed to a constitutional bench, etc. But what the virtual mode did was, it did take the courts to the common man. So today, if a lawyer wants to tell a client what happened in court, it is not just the lawyer's input that the client is depending on. They have the liberty, and I'm talking about the Supreme Court here. Unfortunately, except for Delhi, I don't see many high courts continuing with the hybrid mode. For instance, in Bombay, only one court continues with a hybrid mode and none else. Whereas in the Supreme Court, if a client were to follow what is happening to their case, it is possible to be. They are not dependent only on maybe partial, maybe incorrect, or maybe incomplete information that may flow down to them. And I believe that is true empowerment. So when we are talking about technology taking, justice away from the poor, I think we are actually really losing the thread there, because ultimately, one, that the judiciary has to function within the 4 corners of the Constitution. That it cannot substitute, technology cannot substitute the judicial system. A technology-enabled process cannot substitute the final deciding authority, particularly of constitutional courts, I would say of any court, right? Or even any process that involves even an administrative or a judicial decision. So these are all things we are really jumping the gun on, one, possibly, but taking into account the cautionary note that Professor Sudhir raised and has been discussed by everybody else. Yes, there are vulnerabilities in technology. Ring fencing it is very critical. Oversight, and particularly human oversight, is critical. And finally, I really want to take I want to do two interventions. One is with respect to the question that was asked. Sorry, I lost the thread. I'm going to go back to the chat. But before that, I just wanted to come in on what Usha mentioned. You know, it's a lovely story, and which involves the Lord Shiva. And then the last bit of the story is when even Lord Shiva appears before the king's court and says, I wrote the poem. The king's court's poet replies, even if you open your third eye, a mistake is a mistake. You know, so that's very critical for us to understand that today we live by the rule of law. So nobody is above that law. And therefore, to assume that somebody can actually circumvent or override that law or that constitutional mandate is not going to be possible. So I thought that was a lovely story Usha shared, and I wanted to close the loop on that to say that when it comes to the use of AI, when it comes to courts and its functioning, when it comes to justice delivery, it cannot go beyond these mandates. Even if AI opens its third eye, it cannot be considered right. Even if the judicial system were to say, look, we are empowered, we will do whatever we want, it cannot. It still has to function within constitutional mandates. So the question that I wanted to link to this was about who will decide how the AI will be used. Will it be the government or civil society organizations? I found that part very interesting. See, today we are going through a phase where civil society is involved as part of committees and as part of a transparency process. But at the same time, there is a real and present danger and concern already evinced that through this involvement, is it just opening a back door for industry to come in, right? Is private industry then taking certain decisions? So that is something which is very close to my heart, also the concern that is not for industry to take over. So I'm really concerned that whenever a judicial process or even a government process involves private parties or industry bodies or civil society organizations, it's very critical for the focus to be maintained and a very clear no conflict process to be set out. At least we have to try. Whether it will work or not is another issue, but we have to try. And to make sure that it is not lobbying that is really being deployed. It is not agenda-driven processes that are then being implemented. So when we at least ring-fence that, the other concerns that have been raised by Usha and Sudhir, etc., are possibly things which can be addressed then at an early stage itself, which is to stop an industry-facing necessity that is driving a narrative, or something which is dehogs or beyond what is permissible under constitutional mandate, etc. So transparency has to be real, and it has to work in such a manner that if it is meant for the benefit of common man, let him have a say in it and at the earliest possible time. Over to you, Jenny.
Thank you. I think Usha ji looks like she has something to say, so maybe that's the last intervention we have before.
I just had a quick clarification and one issue that I wanted to flag. One is that on centralization, I was not talking about the use of technology. I actually think any tool we have should be used as a tool. I have no quarrel with that, but it should remain a tool. It can't become something that controls our lives. So I was talking about, you may use technology like that. I was talking about digitization, which at one level seems like just a convenient, efficient, good thing to do, but which consistently has proven itself to be a tool for centralization. We need to be aware of that. And AI is something that's so diffuse that nobody has any clue what we mean. And when they say code is law, it acquires a different meaning when you think of AI. And AI is becoming a big thing now because they've managed to find the technology which will be able to aggregate all this data, anything from anywhere, grab it and put it there, which is what is also creating the biases, which is causing a whole host of things. So I just wanted to make a distinction between these three. We're not talking about these three in conflation one with the other. And the other is that, I don't think it is so simple when it is not the court which asked the government to keep some money aside in their budget for technology. It is the government that said, as part of their Digital India initiative, that they were going to give 7,000 crores, and the courts are now they're kind of rushing to spend that money. So I think it does make a difference. It makes a difference in my recognizing a need and somebody giving me money and saying, this is the need that you have, now use it. And this is where something like the digital public infrastructure becomes important. I don't think the judiciary is insulated from any of this. All this data created, made possible for, like they've talked about this too, that it becomes available to private companies. One thing is to have it driven by private companies and to have this agenda set. And then the next stage where all the data that is gathered will be given to private companies because the governments want to decide what they can do to increase the GDP. And the latest thing, when you say data is the new oil, it's not the new, it's a new everything. So it's a new resource which now has to be exploited to create markets everywhere. And it's that context can never be forgotten because these things don't exist in their little boxes. This is part of a wider, so when Sudhir says that, it may be okay in agriculture or not, actually it's all part of the same, public infrastructure that's being created. And this is when they say digital, it's actually severely data. And whatever they can get, they want to make, some product out of it, to sell it as whatever, and selling just data itself. And just the last thing on guardrails, this is a country where we've not passed our data protection law. We have Justice Chandrachud sitting on the bench and they're saying that, they has said Justice Sri Krishna will be there on a committee. About how many years ago? And they haven't managed to get anywhere at all. So I'm not sure guardrails mean anything. And it is true that even in our conversation today, I noticed that we had shifted from the idea of privacy to harm. Who decides what is harmful? So that, asking for a sliding scale where we abandon privacy and we have to establish harm, we've already got there. So I think all of this, if we don't catch ourselves and think a bit hard from a certain firm position, when I say firm, I don't mean we hold on to the same position, but that we root ourselves for a while and think. There was a word that was used about philosophy of technology. That's the big problem. The technology doesn't have a philosophy. If it does, it's the philosophy of pragmatism and of what it can get. So just, I think that it can't be about application. Our discussions can't always be about applications and whether they are good or bad. I really think we need to have deep and hard discussions on many of these other facets.
Thank you for that, Ushaji. I think that's a great note to close on. You've summed up some of the very crucial ideas and concepts we need to reflect on as we move forward on these issues. Thank you to the panelists for a very interesting discussion. We've talked about sort of global examples and approaches to digitization in courts. We've engaged with, the history of digitization within the Indian context and some of the lessons from there, and lessons from the fight towards privacy. We've engaged with the ideas of rule of law, democracy, justice, and looking at those in the context of the burden on courts and how we can reconcile all of those. We've talked about the practical challenges within the court system and what the deployment of AI can mean within that context. And we've also had some interesting storytelling that has come in through these conversations, which has made all of this even more interesting. So thank you to everyone for engaging with this discussion. Thank you to our participants for a very engaged chat box and for all the questions and comments that have come up through them. We weren't able to specifically answer all the questions, but I think many of the questions have been answered as part of comments that the panelists have made. With that, I'll hand back to Urvashi, and thank you so much to Urvashi, Donna, and Sasha for organizing this discussion, and congratulations on the report again.